So here we are, 2014. And you probably heard this morning's presenters talk about we still have work. My comment during Fair Housing Month, as we commemorate the Fair Housing Act and we try to recognize what it stood for, how far we've come, is I always view it very differently. I would very much like to work myself out of a job. I really would. But unfortunately, it just hasn't been the case in the 4 years that I've had the job. We see different things, different trends, and I'm going to go through a couple of those today. Just speaking of the enforcement piece, we roughly intake about 1,500 complaints. And I think for those of you who have been involved with employment discrimination, one thing that, coming from an employment background that I want to share with you, the Fair Housing Equal Opportunity Unit at HUD has an intake unit, and we do a scrub on everything that comes in. The 1,500 to 2,000 complaints we get to the Southeast region, those are actually jurisdictional complaints. There's a legal analysis done on the inquiries that come in before they're converted to be complaints. So we don't just take anybody who thinks something's unfair. It has to meet specific prongs under the Act. And so the 1,500 on average that we get per year doesn't include the 1,500 or 2,000 sometimes that we turn away. And the categories are, and I think this is consistent with the entire United States, is the largest category of complaints is disability. It's in Tennessee, it's the largest category. Throughout the southeast part of the United States, it's the largest category of complaints. And throughout the United States of America, it's the largest category of complaints. I didn't run the statistics with the analyst, but I suspect that it's probably the largest number of actually caused cases that we have is under disability. Last time I checked, in 12. So I just want to make sure everybody's awake and give you a hypothetical, something that happens routinely. Because in my mind, we have individuals that still see people based on a protected class, and then we have people, really, they're just ignorant to the law. So let me give you a hypothetical for a moment. Something that's very common throughout the southeast part of the United States, unfortunately. And it has to do with reasonable accommodation. So let's just say, show of hands, any property managers in the house? Multifamily? Okay, so I'm coming in to your property. My wife and I are coming in to rent a place. And I come in with a miniature pincher under my arm, and I say, I'm really excited to live at your property. It looks great. And it's very close to my job. I'm happy to move out of the suburbs and get closer to work because Atlanta traffic is awful. Excited to be close to work. And you greet me and show me the place. Everything's cool. And then when I ask for the application, you ask me if the dog is going to be living with my wife and I. And I say, yes, the dog is an emotional support animal. I have a disability. I have a mental disability. And the dog actually helps me ameliorate or limit the side effects that the disability manifests. So, and I have documentation. I'm happy to give it to you because I know it comes up from time to time. Now, the next thing that unfortunately comes out of the property manager or the person showing the property's mouth is we have a pet policy. It's very strict. And my question to all of you, pop quiz, is an emotional support animal, if somebody is a qualified disabled individual and has a service animal, or in this case an emotional support animal, is that dog that I'm carrying a pet? Oh, I tell you, we have hundreds of complaints that routinely tie up investigation. Then when they speak with the lawyers say, oh, yeah, you got to look at the documentation, but yeah, that's not a pet. The next thing that comes in after they talk to the lawyers is, well, I understand that it is a reasonable accommodation, so we've got to take the dog, but we're gonna have to charge you just in case your dog wants to chew up stuff, just for some extra protection. So can you give us an additional down payment? Because your dog is going to be in the property. Is that appropriate? No. Thank you. I'm glad we have a very intelligent audience in Nashville, in the state of Tennessee. Very, very commonplace. And I'm not going to go into ADA law, 504 and reasonable accommodation, but it is so common that I had to mention it throughout the southeast part of the United States. The second largest category are race-based cases. That's consistent throughout the southeast part of the United States. I believe that is the fact also in Tennessee. We still have very traditional race-based cases. Many of them in my region come up in Mississippi and Alabama. Unfortunately, their reputation precedes them in this area. And the one that sticks to mind that is a classic case, and back in 2011 it was a cause case, the Mays case. We had a trailer park, and a young lady was coming home from college on spring break, and her friend, African-American young man, the individual responsible for the trailer park, saw them together and proceeded to say several inappropriate comments to the mother who was living in the trailer, and told him that he had to go. Apparently not fast enough, because proceeded to turn off the water and all the power in the trailer park unit. So that was a cause case that was charged, and there was a significant consent decree, an agreement that was established because the case didn't elect. So we still have those types of cases. On the other end, national origin seems to be the one that is on the rise. It's no surprise, with burgeoning populations of immigrants throughout the southeast part of the United States. National origin in the southeast part of the country, I separated out national origin with Hispanic because we have, if you combine all the national origin cases and Hispanic, it's a very close second to the race-based cases, and it's over 500 cases that we have, and 195 of those are based on individuals of Latino descent. So what it looks like, we had I'm going to go over a case in a moment. Maybe I'll go over it now. This is a recent case that happened in Tennessee. And Fair Housing Council, and this is the one thing that I can say about this case is this is what an effective partnership looks like, because we had a lot of tools and a lot of resources in play on this case. And it was John Tresvigna was the complainant. John Tresvigna was our Assistant Secretary for Fair Housing and Equal Opportunity. And oftentimes we experience with national origin cases, people may be afraid because of their status in this country to file a complaint. The lesson that I want you all to take away, just a reminder, is the Fair Housing Act covers all individuals regardless of their status, documented or undocumented. But in this case, for ultimate protection, the Assistant Secretary was the complainant v. Tritex Real Estate Advisors, and the Fair Housing Council and Tennessee Immigrant and Refugee Rights Coalition provided HUD with sufficient credible evidence for the Assistant Secretary to file the complaint against an owner and property manager of the complex in Nashville, Tennessee. The respondents were accused of allowing the apartment complex property to deteriorate and instructing employees to ignore the maintenance request of Hispanic residents, abandoning its on-site offices, and demanding Social Security numbers or on lease agreements in an effort to drive away the Hispanic residents. They hired a security firm whose employees allegedly intimidated Hispanic residents by following them throughout the complex and demanding to see identification. Finally, immigration and law enforcement raided the apartments, leading to at least 20 immigration-related detentions and causing scores of apartments to become vacant. In the days following the raid, residents asserted that maintenance and security staff told Hispanic tenants that they were to vacate their apartments by the end of the day, and ultimately the respondents agreed to pay out $150,000 to the residents, and there was about 69 residents that received compensation. So a couple of things. This is very common that individuals, I think somebody said it before in reference to the homeless initiatives, I believe it was the statistician that created the PowerPoint presentation for one of your earlier presenters in the testing. It's not uncommon. We had a case just recently in Atlanta that somebody had, it's documented in this country, and had a family here, and their dream was to own the property, paid on the property for years to own this acreage that they were living on. And all of a sudden, when it was time to hand over the title, not so much. The landowner felt like it was, maybe I can get away with the 65 grand that I took, and not give them the property and not give over the title. And then when they pushed a little bit more, landowner said, well, there's some late fees you got to pay, and based on the check stubs, it was very clear that there was payment on time. We did our investigation, and it was a very simple, straightforward case. And what I like about that case is the individuals that lived there were so humble. They didn't even want their money back that they'd paid for late fees. As much as we were trying to get them more, they just flat out just wanted the title, and that was it. And we see that often, that people in positions of power when it comes to housing, they have a tendency, at least in our complaints that we have, to want to take advantage of folks who are limited English proficient. So that's just one example of a case. I want to go back for a moment to talk about, let's see, what's new at HUD. You know, what's interesting is Tracy brought up what's going on at the department. There's a lot more activity in the past 4 or 5 years. And it's not that the tools didn't exist before this administration. It's just under this administration, they are really aggressively attempting to utilize all of the tools. So for the participating jurisdictions, city and state officials, we do our front-end reviews, and we take those very seriously, whether it's a CAPER, con plan analysis of impediments, and we want to work with you. And where we lack competence, we make sure that we partner with individuals to actually give you the guidance that you need. And when we feel like there's just no movement, despite our best efforts, now we're holding funds. There's a civil rights threshold list that we have, and usually when you withhold funds, that's a way to get somebody's attention. That's something that hasn't been done consistently over the years, but there's much more aggressive techniques to make sure that we're partnering, giving technical assistance, consultation if those efforts are not working out. Then we use our limited compliance reviews to make sure that compliance brings forward. And the other tool that we used, I mentioned earlier about the Tritex case, was our secretary-initiated complaint. I'm so glad that we're now using that, because it's a really powerful tool, because oftentimes when we see discrimination, everybody's gone and they've already been evicted and we can't find them. And when we have an opportunity for the assistant secretary to be the complainant, we can go back and provide remedy for these individuals that were actually retaliated against or discriminated against. So it's a very powerful tool. The other thing that HUD has been doing quite well, in my opinion, over the past couple of years is using the systemic investigation. So when an individual calls us through the 800 number, it gives us correspondence and it goes through intake, they're actually putting a better look at it to make sure that it's not a systemic pattern of discrimination. And if it is, it's identified as such, that for when it goes to the investigator, there's a much more thorough investigative plan to make sure that all individuals that may have been impacted by that policy, for instance, that is discriminatory on its face, that we're finding all of the aggrieved parties as part of the conciliation efforts. So those are just a couple of examples. We've been very busy, very busy. We've had dwindling resources, and but just trying to be smarter with the tools that we have. Here's another Tennessee case that's local. It's a local case. The HUD-funded property manager denied the complainant the ability to have 2 service dogs recommended by her doctor. Initially, the provider denied the request because a psychologist and not a physician signed the form. The provider later denied the request from the medical doctor, stating that she could only have 1 service dog, despite the fact that the doctor explained the need for both. Later, respondent denied the installation of a ramp until the complainant disposed of one of the animals. After 4 months, the respondent served the complainant an eviction notice, at which point West Tennessee Legal Service filed the case with HUD. FHE referred the case to the Tennessee Commission for investigation. West Tennessee legal attorney representing the complainant in the investigation successfully settled this case for $8,000. And oftentimes our disability cases, they do settle. Some of our meatier cases that I would like to see actually charged, but with the respondents find out, speaking with an expert, a housing expert, they realize that they've actually violated the law and are willing to work with us to resolve it. Here's another one of the local case. This is one of our FAPs as well, and our FIP. Complaint alleged that the respondent denied her reasonable accommodation after she provided the property manager or doctor's note that confirm the complainant's need to transfer it to a lower level unit. Those of us that work in fair housing, this is very common, the lower level unit. And oftentimes what we see is the person, it's not so much that the reasonable accommodation is denied because they have mobility issues or a degenerative disease that the stairs are too much for them to handle. The issue is when it comes up, they sell it to or they rent it to somebody else. And then they forget about it, their record keeping is in place, and then this individual who really needed that lower level unit is passed over. And so your record keeping and administration is really key when it comes to reasonable accommodation. This is another recent case and a trend that we're seeing. Back in, I think it was 2011, we started with the lending cases and really hit hard. The National Fair Housing Alliance really took the lead on some of these lending cases. And then we migrated into maternity lending cases. Mothers who were expecting and were on maternity leave, they were denied loans, and we had several successful cases and large dollar amount conciliations across the country. Now what we're seeing is denial of loans based on Social Security disability income. So the individuals apply, Social Security disability income is provided, it meets the underwriting requirements, but the loan is still not provided. And this is another secretary-initiated complaint that was just conciliated this week. And I believe the dollar amount is going to come out to about $125,000 for the individuals that were denied the loan because their disability insurance met the criteria and they still were not approved for the loans. So I believe I mentioned all of these. The only other thing that's been interesting this fiscal year, we have seen an increase on familial status cases related to occupancy. And I don't know why we're seeing more of these, but families, a single mother might go with 2 kids and the property manager say, oh, sorry, there's not enough room in the 2-bedroom apartment for your 2 kids, even though the occupancy standards allow for it because there's a perception that the children will tear up the place and there's not enough space for them. And I was happy to see on the agenda that you'll have disparate effect and disparate impact discussed because we have several cases that we're using that standard because there's disparate impact on individuals with families with some of the practices that exist at some of the housing providers in the Southeast. At this point, I'm going to take our 1-800 numbers there, 669-9777. These are all of our local partners in the state of Tennessee. And I know you guys have a 115. And I guess the other thing that I'll say before I get off, and I'll stick around for another hour if you want to ask specific questions related to your programs, whether you're city or state officials, if you got some specific questions or specific cases you want to discuss. But affirmatively furthering fair housing has been around for a long time, since the act was established. And under this administration, the political will was there to put forth the rule. I just wanted to give a status so we don't forget that it's hopefully coming. It's been way too long. But right now there was, I think, a little over 1,000 comments that came in. And the HUD team of policy experts and the leadership is going through every one of those comments and taking the feedback very, very seriously and making the necessary adjustments and tweaks. So I don't have a tentative timeline. All I can tell you, in preparation for affirmatively furthering fair housing regulation, there's teams set up across the country sponsored by headquarters to actually prepare to make sure we have the capacity to effectively administer the new regulation when it does come into existence and to provide the necessary support to help give the consultation to get it off the ground. So that's all I had. I can take a couple of questions before I sign off if you'd like, or you can catch me on the break.
How is the staffing in this region for investigating and handling fair housing cases? How is it trending up or trending down, or how are we doing in this region on that?
We have approximately, let's see, 24 dedicated staff just for investigations. Given that we had dwindling resources in the region and very much more work than we could get at and competing priorities, in order not to jeopardize programs compliance versus grants and contracts or enforcement, we specialize. We did a realignment to have specialized resources. And we have a dedicated team of 24. When we started, it was probably more like 30. But retirements have set in, and with sequestration level funding, we haven't been able to backfill. So we do have more dedicated resources, but we are dwindling, so we're very much looking forward to more money.